Hello, and welcome to the Tech Done For You interview series. I'm your host, Gina Decker, and I'm here with Barbara Ingrassia. Is that how I say it?
Ingrassia, yep.
Ingrassia, and she is a copyright manager and expert, very intelligent. And since I have, a lot of authors and also business owners who are creating content and wanting to protect it, I just jumped at the opportunity to interview Barb here in this series. So if you're not familiar with Barb yet, I'm going to read off her interview or in her bio. So Barb Ingrassia is a certified copyright manager, speaker, and trainer. She has a passion for raising awareness of the role of copyright in our daily lives. As the president of Manage Copyright, she helps organizations navigate copyright law in the digital age by facilitating a review of their public presence, clearing rights, developing best practices, and training their staff. Ingrassia enjoys bringing some fun into a potentially dull subject, and her motto is manage copyright, don't let it manage you. Now, a little bit more about her. Barbara comes from an academic library background. She has studied the murkiness of copyright law with the Center of Intellectual Property at University of Maryland, the Special Libraries Association, Duke University, and the Berkman Center at Harvard Law School. She works with individuals and has facilitated workshops for various professional organizations, both virtually and face-to-face. And so here we are virtually, face-to-face. So thank you, Barb, for joining me today.
Well, thanks so much, Gina, for inviting me, and it's a real pleasure to be here to share with your audience. And you don't often find the word copyright and fun in the same sentence.
That's true. That's true.
And you're right. I consider copyright a gray, murky ooze because it shifts. It's hard to nail down, and with the rapidly changing technology, there are more opportunities, but then there are more ifs, ands, and buts. So potholes and things. And so my goal is to empower you to navigate around those potholes as much as possible. The safest, easiest answer to a copyright question is often, it depends. And but there are some basic principles that I can share with you today.
I'm really excited. I'm really excited that you're going to be talking about this. And I did go to law school, several years ago, for a very short time. I lasted about 4 months. I had an English major, so, I do writing, a lot of writing, and know a lot of authors. But, that's one thing that just drove me nuts in law school, the murkiness and, it's the gray, everything's gray and everything depends. And so, and I'm a very kind of that's why I like tech, it's either broken or it's working. There's a kind of very little in between, so I'm really excited that you're going to talk to this about this subject. Let's jump right in. So, I know several authors, and they're sometimes worried about getting their work stolen. I was learning about WordPress blogs, and you can have a free blog, on WordPress.com, and you can have, kind of like a business website with WordPress.org. But, sometimes they're very worried about posting their writing, because they're worried that it's going to get stolen. So how do they protect that content?
Well, let's go over a few basics of copyright. What's protected automatically, what isn't, and copyright is law does provide some legal protection that allows authors and photographers and creatives to control their works. In effect, they get a monopoly of sorts for a limited time. So what's protected? Literature, music, painting, photography, dance, creative expression. So they need to be creative, original, a work of authorship. Literary is sort of a broad term, and fixed. It must be fixed in a tangible medium. So in print, What we're recording right now is fixed. So it's fixed so that it can be accessed again later. So and there are certain rights that come with copyright protection, and so it's like a bundle of rights. The right to copy, obviously, to reproduce in whole or in part, to distribute, and to create derivative works, translations, your screenplay that comes from your novel or whatever, to perform publicly and to display publicly. So those are exclusive rights of the copyright holder. The person can license them, but it's a bundle. It's not an all or nothing. And so that's an important thing, that you have the option to be licensing someone to use your work, but you have the initial control. Now, it is important to note that who's going to own that copyright? Are you the original author? Yes. But was the work created as an employee? Were you working as an employee? And then the employer would automatically receive the copyright. And maybe there are joint authors, more than one of you who have put this together. And then you all own the copyright. So a copyright happens automatically now. You don't have to register. You don't have to look for the C. You don't have to register to get the C in the circle. The moment it's fixed, it's copyright protected. And copyright lasts for the life of the author plus 70 years. Now, if you're a very young author, let's say you're 30, and you live to 90, that's 60 years, plus 70, that's going to be protected. It's going to be in your estate. Let your heirs know that they have a copyright for a long time. If it's created as an employee, so that an employer owns it, the copyright's going to last 95 years from publication, or 120 years from the original creation. This has been in effect, well, for a while. Since 1978, this fixed in a tangible medium becomes automatically copyrighted has been in effect. So we have a couple of 100 years worth of stuff before that. And so various laws, various rules have applied. And since 1989, we haven't had to have a copyright notice. We haven't had to register with the Copyright Office in Washington. So there are certainly pros and cons to that. And I'll take a breath.
Right. Well, I like how you mentioned, if you're doing writing for an employer, because I used to do a lot of technical writing and, manuals. And, it was my understanding that the university where I, did those manuals for, they own the copyright, so, even just applying for other technical writing jobs, sometimes they ask for examples and I'm like, well, I probably would have, or at least, if I had gone to an interview and needed an example, I can't just kind of give them, I don't know. So,
that's something that's good to negotiate. Oftentimes, if you have an intern or a volunteer creating content, they would be the copyright owner unless you have something in writing otherwise. And so oftentimes an intern might like to have something for their portfolio. So that's good to have, decided in advance. If you're leaving your employer, but they don't know you're leaving, then it might be tougher to take samples along. But yes, that's something to consider. And it's something that can be negotiated.
Yeah.
Best done in writing.
Very good. So you mentioned that copyright is automatic, but how do people alert others that their work is protected by copyright? I know, the bottom portion of the website, sometimes is a very neglected, it's like, do they use their name? Do they use their business? How do they, properly alert people?
And many times people don't scroll down that far, which is a challenge to us as authors. I recommend using the copyright statement, using the C in a circle, followed by the year, and your name or whatever name you want to claim it in, and then all rights reserved. Then adding contact information, maybe an email address where someone can get in touch with you if they have questions, if they would like to use something. All of that creates a nice, secure, theoretically secure package. They can't say, oh, I didn't know it was copyrighted, and oh, I didn't know how to contact you. Another thing is creating alerts, Google alerts, for example, with your name, maybe the title of the work, a unique phrase that is you, that then you'd be alerted when that shows up somewhere else on the internet. But I do recommend registering with the U.S. Copyright Office. It's not expensive, it's quite easy, it can be done electronically, and that gives you a public record with people not having to register. We now have collections of works that are considered orphan works. You can't figure out who owns them. You can't figure out if they're copyrighted, really. I mean, you should assume that something's copyrighted until you can determine otherwise. But this creates a public record. And then some other little bonus is that should this have to go to court, should you have to sue, you get higher damages, you can get attorney's fees. And so completing that registration process is worthwhile. If you're very prolific and you're concerned about having to register so many things individually, you might register them as a group. Maybe your writings from the first quarter of the year and the second quarter of the year, so that that's an affordable practice.
And so, if, an author has multiple books, or maybe some that they're drafting, but they're not published yet, they're kind of not finished. I have author friends, who are writers, but they're not published yet. And so, would they need to register their kind of drafts of what they're working on, with the Copyright Office, or how does that typically work?
Well, theoretically, of course, they're already copyright protected. Mm-hmm. So adding that copyright statement would be a good idea. You could register the various drafts if you're really worried about infringement, or you think it's going to be a long time before you're finished. But you wouldn't have to register each phase. But as we said, as we know, there are people out there who are, well, we'll give them the benefit of the doubt that they're clueless about copyright. And so we do need to take some precautions.
Yeah. Well, that makes a lot of sense, because I know authors who've been working on their novel for years. It may never actually be finished. So if they're waiting to kind of register for their copyright until like they're done, it may never be. I always felt like, I worked on my first book, a memoir, for I think it was 8 years. I ran it through a critique group, and we had 10 pages every 2 weeks, and I ran it through twice. It took a long time even just to get it through critique group. And by the time I was ready to publish, then I registered the copyright. But it took me a long time to get there. So, well,
the law used to not protect unpublished works. It was the publication that sort of set things off, and registering and whatnot. But unpublished works are protected. but probably you don't want to be passing them out to
Just
every
everyone.
company you carry.
Yeah, yeah, that makes a lot of sense. Now, I have heard, that writers, could send a sealed manuscript and mail it to themselves, in an envelope and not open it, and make sure that there's a postmark. Is there any truth to that? Is that an effective way of protecting content?
Well, that's the referred to as the poor man's copyright. And it doesn't really hold up in court because people who are much more clever than I can figure out a way to mail an unsealed envelope to them, get that stamp on it, and then stick something in it later. There are services that you can register with to give a date stamp, which is sort of the techie way of doing that. But again, that's not registration. So it's registering with the US Copyright Office that really gives you that public record.
Yeah, and how much is the fee? If it's inexpensive, about how much is it?
Well, it does vary a little bit. I think it's about $55 now. And
Okay.
so, you skip lunch a couple of times in a month and you're set to go. And again, if you put several things together, that that helps.
Yeah, yeah, that's not really that expensive considering, some people work on their books for a very, very long time. So, sometimes they ask about protecting ideas. Can they protect ideas?
Well, that's interesting. Ideas, copyright protects the expression of original creative ideas. So that fixing is the important thing. So it doesn't protect ideas. There are some other things that it doesn't protect. It doesn't protect ideas or facts, processes, methods, systems, procedures, titles. It doesn't protect titles, data. Most of the work created by employees of the United States government are not protected. They are automatically in the public domain. But again, that's if they were doing that as part of their employment as a federal employee. And then works that have passed into the public domain, whose copyright has expired, or they were never eligible for copyright because of these issues I just listed. Right now, with the life of the author plus 70 years, blah, 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 the safe rule to use is that anything published in the US prior to 1923 is in the public domain. Other countries have shorter copyright periods. And so there are things that come into the public domain on January 1st in other countries that are not in the public domain yet in the US. So the first items to enter the public domain again in the US will be January 2019.
Hmm.
So, again, so ideas are not protected. It's expressing them that's the important thing. Now, plagiarism, that protects ideas. It was ground into us in school that you needed to footnote ideas, direct quotations, that sort of thing. So there's a difference between copyright and plagiarism. One of the interesting examples of what's not protected or is protected is recipes. So listing those ingredients and the procedure to put them together, that's not protected. But when the aspect of writing, when my grandmother made these, the house smelled so wonderful and I have such wonderful memories, that's a creative part. So that part would be protected by copyright. Back in the days when we had telephone books, the white pages were just a listing of facts. And so those were not protected. But the yellow pages where the ads were, those were much more creative, and those can be protected by copyright. So there's some little nuances there.
Interesting. And I, you mentioned titles, and, for business owners, that's a big thing, trying to figure out the right title for their program, a hot title. I just got back from a conference called, JVX, Joint Venture Experience, where we had this almost game where, they would poll the audience. There were little like green flags, and you'd raise them up, it was a good title. But like, do people trademark titles? Like, if they're a business owner, how do they really protect? Because sometimes a title is really, it'll make or break, the sales of the programs.
Exactly. And you're right. The trademarking would be the way to protect that. So some of these things that are not protected by copyright could be protected by trademark law, or, taking it on a little further, could perhaps be patentable. But we see lots of trademarks in our world, and those have been protected. The big names, Disney, Nike, those are trademarks, and you don't mess with those either. But but your title isn't copyrighted, so there could be several. For example, Gone with the Wind. Some title Gone with the Wind. The content inside should be different, and copyrightable for being original or whatever, but that title is not.
That's interesting. Yeah, that's definitely interesting because that comes into play as people are getting website domains as well. Does somebody else have a business by this name?
And yes, domain names can't be protected by copyright, but certainly that's something to think about when naming a business.
Mm-hmm. Yeah, for sure. Very, very handy information. So, if you actually are Googling yourself and you're, searching and you actually find somebody who's used your content without your permission, like, what do you do?
Well, first of all, that's very upsetting. And there are various things to consider. One thing might be to consider, is it a fair use? And that's a whole nother topic, but basically fair use is an exception to the copyright law. Actually, in the copyright law, there's just one section that says what's protected. And then there are many sections that are exceptions for libraries, museums, things like that. But fair use is an analysis process where you look at what was the purpose of the use, what was the nature of the work, was it fiction or nonfiction, published or unpublished, the amount of the work, and its effect on the market. And one of the purposes is for education or research or commentary, criticism. It's possible to be a transformative use, using something in a very, very different way from what the original was intended. So we see a lot of court cases about fair use. Many people will say, well, I'm in an educational institution, so it's fair use. Well, that is just one of the factors in fair use. So that's an analysis process that is an art and a science in itself. And it really is a defense and isn't decided until, if it ever was challenged. Putting that aside, if you think that you have been contacting the party and sort of reminding them that if they didn't realize it, this is protected by copyright, and they please down or give you credit, or even send them a bill for licensing, whatever feels good for you. And there are those contacts would be called desist letters.
Cease and desist letters. Okay.
That's something that there are sites that show you some sort of stock form letters, But that's an area that you may really want to talk with an attorney. So the information that I'm sharing with you today is, I hope, valuable information, but it's not legal advice. And so there may be a point at which you decide it's important enough to consult an attorney. We all know how scary it is to get a letter in the mail from an attorney who's not our attorney. And so that puts fear into our hearts, and hopefully such a letter would put the fear into an infringer's heart as well. Of course, another step is to file a DMCA, Digital Millennium Copyright Act takedown notice. And that would be filed with the host of that website. It could also be filed with the ISP that's hosting that website.
Okay.
And I'll provide some links to some resources to understand that process a little bit. I looked at a source today that was who is ican.org. WHOIS.
Okay.
ICANN.org. So I put in my website, managecopyright.com, and found out lots of things that I didn't know were there. But you test that with your own things, and you'll see who your host is. Maybe it's GoDaddy or whoever, and you'll see who the registrant was for that domain name. And was it me? That has my address and contact information. So you can find out quite a bit about who is behind the screen there. Now, whether or not you feel comfortable pursuing that yourself is a whole nother question. That's another spot where consulting with a copyright attorney would be a good idea. And it could go to court. You could take it to court if push comes to shove. But you have to figure out if that's really worth it, because of course that's going to take time and money. Hopefully you would win and lose the attorney's fees, but it is taking you away from what you love to do or want to do. And maybe it's just not worth it. If it was a one-time thing or a little thing, or photographers face this a lot. And you want to put yourself out there so people know you're around, but then they may take what you have. So there are some additional measures that can be taken. But you may just have to chalk it up to that's the way it is. Having good information at the bottom, again, the copyright notice, but if you're writing blogs, you may want to put at the bottom of each entry that this is copyright. And they need to seek permission in order to use it in whole or in part, and that serves as a reminder. Many blogs that like to be shared will say, seek permission, and it's going to be free, but I want you to seek permission. And that permission is, in a way, a license. So those are things to keep in mind as well. But making it easy for the person really strengthens your case that anything that they've done, they can't claim they didn't.
Yeah, well, that's a really good point, because, I got a question recently, actually within the last couple months, of a business owner who, wanted to cite, I guess as educational, maybe she thought it was fair use, educational resources and give them credit, but without the permission in her course materials. She was designing a new course. She wanted to teach it. She wanted to cite, other resources. And pretty much overwhelmingly, our responses in the group were, you need to ask permission, So is that correct?
That's a very good point. People often assume that if they give credit, if they give attribution, that's all they have to do. And that protects you against the plagiarism thing, but it isn't automatically permission. It's not permission to use. And so you do need to seek permission. Sometimes there are other licenses that people have added. You may have heard of Creative Commons licenses, where the author, doesn't want to get all these permission requests, and so says that you may do this under these conditions. And so sometimes the materials, educational materials, other materials may be labeled that way. You may have heard of the open access movement in journal publishing, that authors want their works to get out there, and so they will opt for them to be open access, which uses a type of Creative Commons license. So Creative Commons licenses can fall between public domain, free to use however you want, and all rights reserved, don't touch it or I'll be at your door. So those Creative Commons licenses sort of fill that gap. And you can register your copyright, but then instead of putting on your works afterward, all rights reserved, you might say Creative Commons license, you may do anything you want as long as you attribute me. Or you can create derivatives, or you can't create derivatives. You've got to share it as is as long as you attribute. It might be no commercial use. You can use it for non-commercial purposes. So there's that nice range in there. And that's something to consider with your own works as well. When you may want to get the word out there and have your things used.
Yeah, well, I mean, I think that's definitely something I learned more about, because I was co-authoring a book, and my co-author had, some images that he found on Wikipedia, and he found this little paragraph in Wikipedia that he thought meant, you can just whatever picture that you find in Wikipedia, you can use it, on a blog post or whatever. And I had heard actually a copyright attorney talk, and she said, there's this process of reverse Google images where you can look up an image, you can upload it to Google, and you can look up what kind of permissions the photographer has given, and you can kind of filter out, based on, can you republish, this kind of thing. And so I ended up yanking, it didn't make my co-author happy, but, we ended up yanking a lot of pictures just because we were unsure, or at least I was unsure, whether we had permission, just to use it based on, having that he found them on Wikipedia.
You're right. Images and photos especially are the thing that most of us sort of fall into. We say, oh, it's on the internet, it's floating around out there. It's easy for me to get. I've got the technology that allows me to do it. If the author didn't want me to use it, or the creator, why would they put it out there? And so all these things that seem logical don't really match against copyright law. And there are ways certainly to find things that are permissible. There are more and more now. On Flickr, someone may post something and they can indicate what kind of license, what kind of use is allowed. So there are ways to search Creative Commons to find things to use the way you want to use them. Maybe you look for I'm going to use the example of brown bears. You do a Google search for brown bears, and you find lots and lots and lots of them. And you say, oh, I like that one. Ooh. Well, upon further examination, you may find that it is all rights reserved. But you can narrow that search so that you do find things that you can use. There are more and more public domain things. In fact, in Creative Commons, some people just dedicate their work immediately to the public domain. no waiting, life of the author plus 70 years. They dedicated immediately to the public domain. So there are ways to find materials that can be used, whether it's images, whether it's music, video, various things. There's more and more public domain materials, but it's always good to look. I mentioned government documents. Those can be a very rich resource, but sometimes on a .gov site, the government has licensed something to make it accessible, but it's not free to reuse. So that's one of the things that is confusing to people. If I can see it, if I can access it, then it's available to me. And that's not always the case.
Not always a valid assumption, right?
Right.
Yeah.
So it's always important to look. And actually the US government materials are pretty good about labeling what's theirs, public domain, and what has been licensed for us to be able to see. So, but that can be a very rich resource of photos, of content, of all kinds of things that can be repurposed. I know sometimes people want photos of, say, a celebrity, and yeah, they'll go and find something on the celebrity's website or something. But and that's typically protected by copyright. Maybe if they did a gig for the US government, maybe they were welcoming troops home or something, and a federal government photographer was there, then there might be photos. Now they won't be as pretty as the photoshopped ones, but you know, that's an option. That's an alternative.
Yeah. And especially, you know, since I work with websites a lot too, you know, I always say, you know, just because you found it on Pinterest or Instagram or whatever, I mean, you can't just assume that they want, I mean, you can always share. Sometimes they just like that you share the post to give them more exposure. But yeah, I mean, usually, you know, if you just kind of download the picture and then you want to use it on your sales page or your website, like you know, that's not, I mean, you can't necessarily assume that you can do that, you know, so you can either do like a Google search on the image, you can contact the person, you know, if you know who it is, you know, but I think there are also websites where you can buy stock photos, you know, so you have a subscription, you buy the photo. So it's okay, you know, they have an agreement, whatever the stock photo site. And then there are also sites that have free, you know, stock, you know, because I recommend Pixabay, Pixabay.com. Usually those are, you know, just I don't know if we call them fair use or just free stock photos, you know, and also the other one I like is unsplash.com, you know, so they're photographers, and when you download them, there's like this little statement that says, you know, you have the option, you know, to give the, you know, the photographer credit, like if you want to use the image, and, you know, it's not required, but at least you have, you know, the option.
Well, and it's sort of like the golden rule, you know, do unto others as you would like to have done unto you, and or do unto others even better than them, whatever.
Yeah.
But yes, the interesting thing about free photos sometimes is, you know, be careful of free, because you just have to be careful to see, is it royalty free, or is it free? Royalty free still requires a fee to actually download and use it. It's less expensive than having to cover the royalty costs. But some of these sites are very clever, and you're seeing these things that you like and they're free, and on the top or somewhere there's this little band of things. If you don't look carefully, you say, oh my gosh, those are wonderful. Well, they've snuck in some things that aren't free.
Yeah.
And sometimes people will, you know, find a way to use those, but typically they've got something across the photo. Stock photo folks are very protective, and a letter from them is really not a good thing.
Uh-huh.
There are more and more ways to do what you want to do to achieve your goals inexpensively, legally, safely.
Well, cool. Yeah. And I know that we've talked about kind of a lot of, details. You mentioned some years, and that's probably going to fly right out of people's minds. So you have a free report where you've kind of given some of these tips as well. Could you tell us a little bit about that?
Yes, I'm very pleased to share something called uh, the top 10 the top 10 copyright mistakes small businesses make that could land them in court and how to avoid them. And you might think, oh, well, I'm not a business. Well, in a way you are. You're a solopreneur. If you're writing, you're seeking to publish or whatever, you are a small business. And so that outlines the 10 assumptions that we talked about a few of them, and then some ways to avoid them.
Hmm.
For example, assume a work is copyright protected until you can determine otherwise. Don't be just grabbing any old thing from the internet because that content is protected by copyright as well. It's so easy for us to search, copy, paste, send in seconds
Yeah.
without thinking about who might own that. And so
Yeah.
that's when I think it's important uh, for businesses of all sizes to be aware of copyright. Make sure that the staff members are aware as well. And that's one of the things I like to work with.
Yeah, yeah, and I'm glad you're talking about this because even just the other day, I was talking to a business owner and she had she had a membership program, a membership website, and she, uploads her videos to YouTube, and so, they're unlisted, meaning, they have to have that exact URL to know, to be able to kind of view that if they haven't, paid for their membership. But she was concerned. She was like, should I switch to Vimeo? I mean, that's going to take a lot of time. And, and what we kind of, said is, sometimes people, if they'll steal it, if they go out of their way to, there's never just 100% secure, whenever you're putting something out. I mean, it's not a guarantee. And so, it's when you embed the video, that's different. Like when you embed it on your website, there's maybe sometimes a button to click and watch it on YouTube. And sometimes you can disable that in the code and you can kind of have, settings on your website so that you're just embedding and they can only watch it on your website, and that's a little bit more secure than, just uploading it to YouTube, because I'm a pianist. I play classical piano, and I actually had Googled myself once under my maiden name and found that, a piano performance that I had uploaded to YouTube, somebody took it as an audio and then they put it on their website. And I was like, oh, well, they never asked me if they could do that, So, I mean, I don't really care because it's, I didn't really have that many views on the piano performance, but I was surprised. I was pretty surprised that they had done that.
Well, that's a very good point about music. Many piano performances and recitals and orchestras and whatnot will use sheet music that's out of copyright. And, the Bach, Beethoven folks. And they're doing that because it's not copyright protected. So that there isn't this public performance thing going on. But interestingly, once you record it, and it's the Gina Decker Golden Hits, that recording is protected by copyright. So even though what you played wasn't in copyright, you were working from the sheet music, your recording is protected. And it's going to be a long time before copyright expires on those kinds of things.
Ah, well, that's good to know. That's good to know. So, and
I'll be looking for the Gina Decker Golden Hits.
Oh, it might be under my maiden name, a cow. I could. That's. I had a lot more when I was working on my music major. I have a bachelor's in music, and I decided not to do performance, but I almost wish I had recorded more, just because now today, there's certain things in my repertoire that I've practiced and maintained. But, when I was at the peak of my music major, I could play concertos and really cool stuff, and Beethoven sonatas with all the movements, and now I can't do that. It would take quite a lot of time to resurrect those pieces.
Well, and so those people who took your recording could have gotten the sheet music if it was out of copyright, Bach, Beethoven folks, and played it and recorded it, and that wouldn't have been a problem. But the fact that they took your recording wasn't right.
Yeah. Well, I didn't send them a lot. I mean, I didn't really care about that. Yeah.
Aware, and that copyright applies to us every day in our lives.
Yeah.
Not just the rich and famous, the famous authors and musicians and all of us, because we all create things, whether we think they're going to be world famous or not.
Yeah.
And that idea of fixing, you could scribble an idea on a napkin, and that's fixed. Your name might not be on it, so it might be, in effect, an orphan work. It might be a sticky note that you find on the floor of the subway, and again, you don't know whose that is. It's an orphan, but that is fixed. That's copyright protected. So it's very far-reaching. And we've had copyright in effect since before the country was, and it appears in the Constitution. The idea that Congress can make laws to offer this limited time monopoly in order to encourage the creation of works, of literary works, so that the country was developing its own culture. And when copying meant copying by hand out of the Encyclopedia Britannica or something, it was a slower process.
Yeah.
It could still be figured out by good English teachers and whatnot, but it was a slower process. And now it can happen like that. That's what's brought copyright back to the forefront.
Yeah, yeah. Well, I see Janine had joined us, and she may have some questions, as well about copyright, because she is creating a program. She's the one who's uploading videos unlisted to YouTube, and concerned about the copyright, and the rights and protections to that. And of course, I'll send out the replay to this to anybody who's interested. But I want to make sure, because we have a special offer, because this is a really kind of deep topic. There's a lot of gray area. If you're creating a lot of content, especially if you have a business or if you're an author, if you worked on this stuff for a long time, how can people contact you and kind of get more information if they're just kind of, oh, this is not quite enough, to answer their question?
Well, you'll be posting a link to the free report, and some of the sites that I have mentioned today. If you get the free report, then I will get back to you another sheet of some of these specific websites that I've mentioned today. And then right, because we can't, we couldn't go into as much detail as is necessary. As you can tell, it is a dark, murky subject. Sometimes to my presentations, I take my goggles and my boots. So you may have more questions about you protecting your content, but also about the content that you have wanted to use. So I'm pleased to offer to your listeners, to your audience, a 90-minute consultation to discuss whatever questions you may have. Now, this is going to be information, not legal advice, but certainly when I run into the gray murky ooze up to here, I'm going to tell you this is something to consult with an attorney. But I'm pleased to make this special offer for 90 minutes, a 90-minute consultation for $350. So that's an opportunity for the two of us to talk about your specific interest, to get down to some of the nitty gritty that applies to you, that you raise your examples and your questions. So I'm very pleased to make that special offer to my.
Well, I really appreciate the discount because I know, sometimes, we get into these situations. We're in business, we're flying by the seat of our pants, and then we kind of get into these, copyright questions, and it helps to have, somebody who's more informed about it. So I appreciate that. And those links, I put them in the chat and also put them in the replay email, but techdoneforyou.com // Barb gift is the free report with the 10 mistakes that business owners make with their copyright. And then the consultation is at techdoneforyou.com / Barb consult. And so I'll include those links with the replay. And we have a little bit of time for Q&A. So I'll unmute Janine. If you're here, Janine, and you have a question about copyright and protecting your content, even your membership content, Barb is definitely an expert in copyright. She knows a lot more than I do about the topic. So I'm excited that we've gone over this topic today.
I think for me, the hardest thing is it takes so long to write copy. For those, when copy doesn't come natural to you, it takes so long to write copy. And then, you put your blood, your sweat, your soul into, your copy and your website and your program. And then it is disappointing when you find, well, there's a couple of things. Either people who are in a paid program share their access to others. And so, for me, I'm thinking about now, because I've done my launch earlier this year, but it's now something I need to have a more mature approach around, is making sure that somehow that the students understand that by agreeing to the program, that they are agreeing to the terms and the conditions, and part of those terms and conditions is that the content cannot be shared and their username and password is unique to them and it cannot be shared.
Right, you're right, and that is a challenge. First of all, people don't roll down to the terms and conditions and privacy statements and don't know what that all means. If they've been required to click agree or sign something, then in effect, that's a license. That's a license agreement, a contract. And if push came to shove, you could consider violations of that to be breach of contract. You could,
or maybe
find them of that, but it could go, you could take it to court.
Yeah. And to me, it's the how. So I've got my terms and conditions. I spent time, money, effort, and resources on putting together the terms and conditions. I didn't have it at first. It's something that we thought about afterwards, because you're so excited doing a launch and getting your program out there, that it was a thought that came afterwards. And so now it's a case of how, and what I mean by how is, how do I get them to acknowledge it? And I don't want it to be so obtrusive that, I scare them away. Or maybe it's just something as simple as a checkbox with a link to the terms and conditions, and I just have to have them check that checkbox. And, being conservative people, they should check what those terms and conditions are before they check that checkbox.
You're right. That could be a good solution. One thing about terms and conditions and privacy statements is that's a good thing to consult with an attorney, because if we, in general, we think, okay, I'd like to have some of those, and I see somebody who did a great job with it, I'll just copy theirs and tweak it. Well, that's copyright infringement on their terms and conditions. And so copyright attorneys have told me that it's very difficult to cover all of the bases of your particular situation. So, but I agree with you that having a checkbox, and we all see those, and we've checked that we have read them, the terms and that we agree. And all too often we say, I haven't got time for that, click, click. Well, you know, one of the dangers of not reading a license agreement is that you might breach it. And so it is legally binding, and it's good to remind your members of that, because yes, you have put your time and talent and heart and soul into it, your finances, and so your livelihood and your reputation and whatnot are resting on.
Yeah, I know, I agree wholeheartedly. And then what about just for blog posts? Where do you put like a copyright statement, or how do you in your blog post, because they're public? So they're the two sides of my business. I've got the public side, you know, where we're putting all of our public content and it's public, you know, and then you've got your private coaching program. And that's the one I really wanted to make sure I locked down and made sure people understood that, you know, it's an individual user license. They can't share it around and they can't share the content. But the second side is really that public side, things like your blog posts.
Yes. Well, it's always a good idea to put a copyright notice on it. Copyright year, your name, all rights reserved, an email address or something to contact you. And sometimes you just have to explain that it should not be reposted, or you should not take pieces of it.
Should not be reproduced without permission.
Thank you. Yes.
Yeah.
Yes. Yes. And sometimes you have to tell them even that in any format, print, electronic, audio, video, whatever, and sometimes even the licenses you see when you're working with a publisher used to say at least, or any format now known or not yet known. So they cover themselves for the future. But yes, as I was saying earlier, there are certain things that from that bundle of rights that you can decide to license away, and just license away the minimum of what's needed to get the deal done. You're right, you get so excited about the opportunity to be published or whatever, and the agreement looks like, you know, legal gibberish, and so you just say, oh, I'm so excited, I'll sign. And sometimes you signed away some things that you don't want to sign away.
Well, and sometimes that legalese is hard to read.
Oh my gosh, yes. So,
I mean, it's like, oh my gosh, give me 10 cups of coffee so I can really try and understand this.
well, and so in a license that can be negotiated like that, oftentimes the click ones, it's either you agree or you don't use it. You don't use it.
Yeah.
But something that's more formal and can be negotiated, it's always good to ask about anything that you don't understand. And what does this mean? And get those explanations in writing. So you don't want to sign away all the foreign language and screenplay rights and whatnot to a publisher unless you want to, just so that you're well informed about what you're actually giving away and getting into. So
Yeah.
those are good questions. Thanks for asking them, Janine.
Yeah, so this is certainly top of mind for me right now where I am. And so it's definitely on my to-do list, my agenda to get tighter around, you know, the terms and conditions, the privacy agreements, those kinds of things.
Yes, and so you can look at some things as examples and as stock examples, but then you might be able to have crafted a draft of something that you might then take to an attorney, and so that might save some time and some money on your end. So being an informed person is an important step, and that's what I'm really trying to do, is to raise awareness and educate and empower people to understand more about copyright in the digital age.
It's really about protecting your business.
Yes.
Yeah. Well, thank you, Barb. It was lovely to meet you.
Well, thank you. Lovely to meet you. I suspect you're across the pond.
Actually, I live here in the US now, but yes, originally I am from Australia.
Ah, a lot of ponds.
Yeah, one rather large pond. Yeah.
Best wishes on your endeavors.
Thank you so much, and thanks, Gina, for setting up the call.
Oh, you're very welcome, Janine. You know, I get a lot of these, copyright questions, that kind of come by my desk. And like you said, like I actually added a link to my terms and conditions. So when people buy, in WooCommerce, which is what I had on my website, they have to check the box to acknowledge the terms and conditions, before they place the order. So, I mean, that was just something I added to my website. But I mean, we could definitely discuss, kind of just how we could, formalize some of the legal.
The how.
It's very common that, I mean, I've had people send me logins to stuff, oh, I just wanted to share this, this membership, site that I bought or whatever, it's a violation of the creator's copyright.
Yep, I agree wholeheartedly. Yeah, so now I'm just looking to say, what do I need to have in place so I can better protect myself? And in the event somebody does violate it, I mean, sometimes people aren't malicious with the way that they violate it. They could just be, with their mother, their sister, their spouse, right? And then other people really are more malicious, with the way that they're sharing. And so they're the ones that you really want to protect yourself from.
Yeah.
Right. Yeah. And so sometimes that's when you have to send a letter, or sometimes you even have to, if they posted it on a website, you may have to take extra action to have that taken down. Gina is very aware, but anybody practically can set up a business to create websites, and they aren't going to be necessarily as informed and aware as Gina. That's true also, unfortunately, with graphic artists or people that you depend on professional and knowing the rules and regulations. But you need to be aware of some basics yourself so that you can be asking the right questions.
Yep, absolutely.
All right.
Gina is top notch.
Well, I go out of my way, and I do have a legal background. And we always say, we were taught in law school, this is not to be construed as legal advice.
Yeah, exactly. Well, that's the same with me as a health coach, right? This is not like physician. You should always consult with your physician, right? It's the same. You should always consult with your legal, advisor, or seek legal advice.
Yes, exactly. Well, thank you so much, Janine, for joining us. And thank you, Barb. I mean, this was a wonderful interview. Thank you for sharing this information. I mean, you even kind of reminded me of stuff that I didn't, I hadn't thought about in a long time. So, I mean, this is really, really good information. I appreciate you coming today.
Well, thanks so much for inviting me. This has been fun. Thank you.
All right. Great. And I will send out the replay and also the link to, Barb's free gift, with all the tips on copyright in case you didn't get any of these, details.
Yeah, this went fast.
Yeah, I highly encourage the free gift, techdoneforyou.com/Barb gift, and then the consult, techdoneforyou.com/Barb consult. We are here to help you. So thank you and have a great day, everybody. Bye.
Bye.
Bye.